When you're ready, counsel.
Thank you, Your Honors. Good morning. May it please the court. My name is Thomas Pilasak. I represent the group of retired Tampa police officers and firefighters who are the appellants in this case. They appeal from the dismissal of their breach of contract claim, not because the complaint on its face failed to state a claim under Florida law. That was not the reason for the dismissal. Instead, the reason for dismissal was something else, and that something else was that the lower court concluded that application of Florida's Public Employees Relations Act, the public sector bargaining law, defeated their claim because that law permitted the unions and the city to bargain away their contractual rights without their consent after they retired. And also, the court concluded that notwithstanding the facts that they were no longer employees who were covered by the Public Employees Relations Act, as the lower court acknowledged, nevertheless, they were obligated to exhaust alleged administrative procedures that were provided by Chapter 447. That is the grievance to arbitration procedure within the collective bargaining agreements of the firefighters union and the police union that the statute required to be enacted. What I'd like to focus on today to explain why both of these reasons for dismissal were wrong is to go to an overview, a practical discussion as to how exactly the law works as to active employees and as to retirees who are not active employees within the union's bargaining unit. In fact, I guess the better way to express that is the contrast is between how it works for active employees and how it doesn't work at all and doesn't apply at all in the case of retirees. We know the facts. The court is ultimately familiar with them, I'm sure. The appellants were granted a present right in 2001 to participate in a pension enhancement to be effective starting in October of 2004. The appellants were all required, because they were in the drop program, to retire prior to October 1 of 2003. And they did. As soon as they retired, within days, the city and the union got together and cut them out of the right to participate in the pension enhancement. And that is the basis for the complaint. We have alleged that the appellants as third-party beneficiaries were granted an inalterable right based on the language of the agreement itself in the appendices that apply to both the police contract and the firefighter contract to participate in the benefit. And on its face, that appendix or those appendices provided that it couldn't be altered through subsequent bargaining. The question that remains is whether or not the city had a duty to bargain with the police and firefighter unions over their participation in the enhancement after they retired for active employment. And the answer is no. Under the Act, if they were active employees when the bargaining occurred, they would be bound by the results. But because they were not, they are not bound by the result. And the reason why they are not bound by the result is that starting with the Pittsburgh plate glass case back in 1971, where the Supreme Court said that retirees are not bargaining unit members. There was not a sufficient community of interest. And in fact, other cases we cited in our brief have held where the unions have an inherent conflict of interest with retirees. The unions have no duty to represent retirees. The city, on the other hand, has no obligation to bargain with the union over retiree benefits. And that's in an example of it, at least, is in the Zelensky case that we cited in our brief as well. The crux is that the question it presents is whether a city which has no obligation to bargain with the union over a class of persons, notice they're not employees, persons, who the union does not have a duty to represent, and under Chapter 447 has no statutory authority to represent because they are not within the certified bargaining unit, whether by doing so they can bind appellants to the benefit of their bargain to cut them out. And the answer is the contract controls, not the law. That is a decision on the merits. Courts should have made it, and in fact, it impliedly did in a roundabout way by saying, oh, well, reading this, it wasn't the right to receive the enhancement wasn't guaranteed. Well, that's an interpretation of the merits. We contend that the language is clear and unambiguous, that the city and the union agree to support a special act which provides for the enhancement. And the next paragraph says, the special act shall provide that the 3.5% accrual of benefits apply to all active employees, including drop participants. Notice this is in 2001. The appellants are still actively employed and they are in drop. And those beneficiaries include drop participants employed on or after July 1, 2001. And there's no question that the appellants all were. It further provides any increase to the pension contribution rate, any increase, notice not the 3.5%, which is left to future bargaining based on cost considerations, but any increase to the pension contribution rate effective October 1, 2004 shall apply to all active employees, including drop participants. Paragraph 2 down. In the event that an active employee, including a drop participant, separates from employment on or after July 1, 2001, but prior to October 1, 2001, as appellants all did, because they were required to do, then the employee's retirement payment shall be recalculated to reflect the increase, not the 3.5% increase, the increase in the accrual rate with revised payments effective October 1, 2004. At the end, it says this amendment shall be contained in any successor collective bargaining agreement until becoming law October 2004. On October 1, 2003, the city and the union both signed that agreement. They cut the appellants out from eligibility to receive the pension enhancement, contrary to the very language we just read. And it is that breach which prevented the enactment of a special act. The process is, obviously, and the court knows this, you bargain first, you get an agreement, you present that agreement in the form of a special act to the legislature for its consideration. The legislature then acts on it because it has the authority, as this court noticed in the Arts case back in 2012, The legislature, under the city's pension plan, is the authority to implement any changes to the pension plan. In this case, the legislature was not the funding authority. The city was the funding authority. It may have gotten contributions from the active bargaining unit employees who were still there, but the ultimate obligation to fund the pension is the city's. It is the city's pension plan. The legislature didn't have a dog in the hunt, I guess we could say. And the reason why they didn't have a dog in the hunt is because they had no independent interest in turning down what the city proposed, whoever it may have included. The problem is that because the city and the unions excluded the appellants in breach of their 2001 agreement, the special act was never proposed. It prevented the legislature from passing it in breach of the city's obligation I just read to you in the first paragraph. The dilemma this creates is the second issue we get to. That is, well, assuming that there is a breach of this irrevocable promise, which we contend, which of course is the decision on the merits to be gleaned from the language of the contract, then what's the remedy? Well, the remedy is, we believe, for breach of third-party beneficiary agreement that was brought, and that is on appeal, and that was dismissed. And it was dismissed because the lower court said that even though the appellants are not employees who are covered by the act, nevertheless, they have to exhaust statutorily provided procedures that apply to active employees, to retirees who are not even covered by the act. And not only that, this court had ruled in Arts 1 in 2012, where the lower court had previously dismissed for lack of jurisdiction based on preemption by the act, that because the appellants then were not employees, there were no remedies available under the act. In that case, it was an unfair labor practice, but there are, as the court noted, additional remedies available to active employees. That is the grievance arbitration. If these were active employees when this occurred, if they were outvoted by the remainder of the bargaining unit, if they had a chance to participate in the vote, but lost, they would have no claim. If there were a separate breach of contract they were complaining about, the remedy would be through the grievance and arbitration procedure. And that would be the exclusive remedy. There would not be a basis for a lawsuit. But in Arts 1, this court determined that because there was no remedy available under the act to the employees, that the court had jurisdiction to decide their claims. And so we invoked the jurisdiction was invoked. The court has jurisdiction to decide the breach of contract claim, and they're not required to exhaust the contractual remedies, which would be futile. And by the way, there's a small distinction, I would think, between the 2012 decision in Arts and what happened in this case. In 2012, it was a jurisdictional situation based on preemption. In this case, what the court really did was to rule on a defense an affirmative defense, failure to exhaust. If the basis for the court's ruling was that the statute required it, then it would be the same thing, jurisdiction. And the case would be governed by the first Arts case in 2012 and would require reversal. But if it's considered a failure to exhaust defense improperly decided, then we have to also, besides the statute, take a look at the contract. The collective bargaining agreements in this case are only available to employees. They only cover employees within the bargaining units that are represented by the union. Retirees are neither. They're neither employees nor are they within the union's bargaining unit. In addition, if you take a look at the grievance process, the procedures in both of these contracts, they're not amenable to pursuit by retirees. First of all, they have very short timelines for filing grievances. Under the PBA contract, there's a 14-day time to file a grievance if an employee is complaining about a breach of a collective bargaining agreement. Under the firefighter contract, there's a 7-day time limit. These people are retirees. They're not even working. How are they supposed to even know that the union and the city bargained away their rights and breached the agreement? Let's even get beyond that. The initial steps are at various levels that proceed up a certain chain of command. Retirees don't have a chain of command. Those procedures are useless. They are futile. They are meaningless. And then we get to the final step, arbitration. Under both contracts, only the union can invoke arbitration. And under the firefighter contract, the union has to pay a filing fee with AAA. This is the fox guarding the hen house. The same party who breached its own obligations in collusion with the city to violate the contract is now in charge of referring a breach of contract grievance that they participated in and caused to arbitration. Makes no sense. It's futile. And as this court noted in Arts 1.
Sir, I just want to give you a signal on your time if you want to save some for rebuttal.
Thank you, Your Honor, I do.
Okay.
The courts noted in Art 1, the law does not require a futile act, and I will reserve the remainder of my time.
Okay. Thank you. Mr. Gonzalez?
He's muted.
You're muted.
Thank you, Judge. I don't know how many times I need to do a Zoom hearing to where
I understand.
but I apologize. But with respect to this case, I think what's essential is what's before this case is one part of an order dismissing a case with prejudice. And the one part that is on appeal is a motion to dismiss a claim for breach of contract based entirely on third-party beneficiary law. And I think it's important to center where this appeal is in the course of this case, which, as the appellant has noted, has been around for a long, long time. And that is that importantly, as the appellant concedes in its brief, when the fourth amended complaint was dismissed, it was dismissed without prejudice for the current appellants, but it was also dismissed with prejudice for the claims of 7 command staff plaintiffs who were not members of the union's bargaining units. And that dismissal with prejudice was affirmed per curiam by this court at 229 Southern 3rd, 1228. those original plaintiffs had always argued that they were third parties, and their claims were dismissed without prejudice. So in a large way, the question of whether or not somebody can be a third party beneficiary of these agreements has already been resolved and not appealed. But going beyond that, what's important is that the current appellants were never third parties before this appeal. They were in fact members of the bargaining units that were represented by the union. And as proof of that is the complaint as stated is clearly leveled against both the city and the union. And the dismissal was to both of those, and there's no appeal of the dismissal against the union. Because what was alleged, and in fact it's in so many words, is there was an allegation that the city had, quote, with the cooperation of the union, end quote, negotiated for a change. And that requires me to point out that this is all about an appendix, and the appendix in the appendix was a promise by the city to support a bill. There's never been an allegation that the city refused to support any bill that was proposed by the union. In fact, there's an affirmative allegation in this complaint that the changes that occurred to the statute that was finally given to the thing were proposed by the unions. Those are specific allegations of this complaint. It was the union who realized that the appendix provided this. The city was to pay the bulk of the cost of the pension and contribute that into the pension fund. And the employees were to make contributions. And the city's contribution was capped at a percentage of pay. So in terms of people not having a dog in the hunt as to wanting to change the original, rate, the multiplication rate, the fact of the matter is that the employees who were active employees, including these plaintiffs who were in drop, were still active employees, but because they were in drop, they would not be paying any contributions. So the city would gain nothing by leaving them out, and it would gain or lose nothing by leaving them in, because the payments to the individual retirees were going to be made not by the city, they were going to be made by the pension fund, which would be changed. So what's being argued now is that the employees who were not third parties at all, they were in fact members, and as the appendix plainly says, there was a provision that said that this provision, the obligation to support a bill, would continue until the effective date of the law, which is written into the appendix, is October 1st of 2004. And during all the times that this contract could be violated, then the appellants were not retirees. They were in fact employees under any interpretation of PERC. Because the appendix doesn't refer to these appellants by name, it simply refers to the fact that all active employees, who are the only people that a pension rate is going to apply to, are going to be getting this rate, including those who are in the drop program, because although they are in the drop program, they're still active employees. Now, what the union, what the appellants are arguing now, having accepted that the true third party litigants are no longer in this case, they're now saying that they were third party beneficiaries. But of course they weren't, because they were members of the bargaining unit when the promise was made. And so there was no way they could be third party to this contract. But even if they were third parties, then the appellant in his brief notices that a promisor and a promisee can by agreement create a duty to a third party. Even in the absence of a non-variable duty, the power of the promisor and promisee to discharge or modify the duty owed to a third party by subsequent agreement terminates when the beneficiary, before receives notification of a discharge or modification, either materially changes his position in justifiable reliance on the promise or brings suit on it or manifests assent to it. None of these appellants in any way change their position in reliance on any kind of promise. And more to the point, it's affirmatively pled in this complaint as it now stands that each and every one of these appellants had entered the drop program before the first contract was agreed to. And by entering the drop program, they had no choice but to retire when they retired. It was impossible for them to make a material change in reliance on this. And none is alleged in this complaint. And what the appellants now say that they were third parties and there was a breach and the not only the city could not change its position, but they would also prevent them from fulfilling its duty to negotiate with the union. And in terms of the argument that's just been made with respect to PERC and the whole thing, I'd ask the court to just consider and review the record and remember that the order that's being attacked addressed counts that included a deck action, a breach of the contract, a breach of a fiduciary duty, and civil conspiracy. And all of those were dismissed with prejudice, but only one survives here, and that's this claim based upon a theory of third-party beneficiary. And so what is being argued here, Your Honors, is that a third-party beneficiary, even if these people are a third-party beneficiary, has rights that can overcome not only the rights of public employees to bargain collectively, because that's guaranteed in the Constitution, but they can also have rights greater than the people who negotiated the contract in the first place. And in the absence of reliance, Judge, that can't be something that can be argued. But more importantly, what happened here, and it's pled in the complaint, is that there was an agreement to support a bill, and the bill would provide for a specified percentage contribution for members of the police and fire pension fund. And into the appendix is written mention of the fact that there are being studies done on the cost and a cap on the city's contribution, meaning that everything over 10% of the employee's compensation was going to be entirely the responsibility of the employees, which did not include, by the way, at that point or ever, the appellants, because they were never going to make a contribution. But everybody else represented by that union was going to make a contribution. And as is written in the complaint, it was the union that proposed a change, and the change was to go from a 3.5 to a lower percentage. And it had every right to do that. And no one can challenge their right to do that. And with respect to the original complaint, there may or may not have been questions about PERC's involvement and whether PERC's ruling was right or like that, but not in the context of the only ruling that's appealed. And that is a ruling that says that they had a right as third-party beneficiaries to convert an obligation by the city, because all the city agreed to was to support a bill, they were never going to pay the full cost of the benefit. I mean, the full benefit was not going to be paid. That was going to be paid by the pension fund. And now alleging that there was some kind of connivance, I think that they call it connivance in their brief, between the unions who are no longer sued and the city. They want the city to pay the entire cost, the entire benefit, backwards and forwards for these few people, so that they get a 3.5% increase or multiplier, whereas everybody else in the union, everybody else covered by this plan, is going to take a 3.15 and pay for it. Your Honor, it simply is not something that can be recognized under any theory. It's not a theory that was urged below. This case was argued at the motion to dismiss by an attorney who did not draft this complaint, and the conflation of a claim for third-party benefits by persons who are not members of the bargaining unit can't be allowed to get turned into a claim by people who were in the bargaining unit at all times relevant to this case for a claim for breach of contract. And we'll yield back the rest of our time. Thank you.
Thank you. All right, rebuttal.
Thank you, Your Honor. Just very, very briefly, there's not really much to say. We don't understand the contention that the appellants weren't third-party beneficiaries. They were actively employed, they were covered by the appendix, and they were within the class of people that were specifically named in the appendix. They are intended third-party beneficiaries. And we have pointed that out in the reply brief. We pointed out our befuddlement with the lower court's agreement with the city's position in its order of dismissal. And we are still puzzled by it. We simply do not understand. And the reason why we don't, I think, is because the city has no law to support its position. We do. As far as the plea goes that the unions want the city to pay the entire cost, well, they always have the right to sue the union for contribution or indemnity if they want to. If they don't think they're responsible for it, the unions are no longer in the case, but they can be brought back in as third-party defendants. So the long story short is that bargaining laws don't apply to this case. We think the language of the appendix is clear and unambiguous. It grants an unalterable right because the lower court read the language of the appendix and in part ruled that it was not guaranteed, which is an interpretation of the language of the appendix. This court can review that de novo. We ask it and invite the court to do so, but at the very least, in order to avoid coming back up here again, we would ask the court to clarify with instructions to the lower court on remand that this case is simply subject to ordinary principles of contract interpretation, period. It is a straightforward breach of third-party beneficiary agreement complaint. It is plenty of Florida law on the topic, plenty of common law about how you interpret and apply contracts and the canons that apply. And those are what govern, like any other agreement. And we thank the court for its time.
Thank you. Thank you both. And that concludes our docket today. So court is adjourned.